Hi, it's Mark Gracie here from the Digital Compliance Hub. Thank you very much for joining this webinar about GDPR privacy and websites and where the compliance from GDPR and privacy fit into what you might be doing with your website. Just to let you know that the session's being recorded, and I'll provide a link to a copy of the slides and a copy of the recording. So if you need to revisit what was covered or want to have a look at the slides, then you'll get a copy of those afterwards. There's a question panel or a question section in your control panel for the webinar. If you've got any questions, then please use this section in the GoToWebinar control panel. And I'll pick up questions at the end. I'm expecting to talk for sort of 30-40 minutes, and then we'll get some questions at the end. Obviously, if there's no questions, then we'll finish after the presentation, but I will finish at 1 o'clock. If there are lots of questions, then we'll cut it off at 1 o'clock. Okay, so let's get started. So as I said, my name's Mark Gracie. I run the Digital Compliance Hub, which is a support service for helping businesses with their data protection, data privacy, and data security compliance. And my background is very much in technology and internet, and also I've been a data protection officer and am a data protection officer within various different types of businesses. So I've got a good understanding of how websites work and some of the intricacies of technology. And also the understanding of the law and the compliance, which is why I'm able to bring this webinar to you about both websites and where compliance fits into that. So, as I said, I'm going to talk for probably about 30-40 minutes. We're going to have a look at where GDPR privacy and privacy sit with regards to websites in a general view overview, and then look at some of the detail and some of the things that you should look at. And also a checklist for you to use as a way to perhaps consider how you might want to audit your website to see whether it meets all of the compliance requirements. What I would say is that on the face of it, you would think, well, actually, just make sure that you've got consent on your contact forms or where you're collecting information for signing up to newsletters and things like that. And of course, that is important. You might need to think about your cookies, and on the face of it, those are probably the key things that most people think about, but it's not until you perhaps look at what your website's doing, the functionality of it, and where the data protection and the privacy rules fit into that you realize actually there's quite a few different things to look at. So I hope you find the webinar useful. As I say, if you've got questions, we can pick those up at the end. Just use the question panel in GoToWebinar. So let's start looking at sort of an overview, I guess. So the two key regulations which we'll be talking about is the General Data Protection Regulation, which in the UK, we also have the Data Protection Act 2018, but I think we all probably have heard of GDPR. You might like it or you might hate it, I don't know, but I've picked out there three key areas that are applicable to websites. So that's the data protection principles and what you can and can't do, the lawful basis for processing, and individual rights, and I'll talk a bit more about what those mean from a GDPR point of view in a second on the next slide. But we've also got the Privacy and Electronic Communications Regulations, or PECA, which is a 2003 regulation, and contrary to popular belief, still exists, still controls what you can and can't do with electronic marketing, still controls what you can and can't do, or what you should do, I should say, with the use of cookies. If you attended a cookie webinar around a couple of weeks ago, then we focus purely on the PECA rules around consent and cookies and what they mean. But these privacy rules sit alongside GDPR. They're not replaced by GDPR, but they do set out what, as I say, what you can do with electronic marketing, so things like email and phone calls, and the rules around the use of cookies, which of course is a key thing when it comes to websites. I will add a caveat, and somebody asked me this week about the suggestion that the new European e-privacy regulations that are supposed to be happening anytime now They were supposed to happen last year when GDPR came in, but they haven't materialised, and they're still being debated at the EU level. They may impact a lot of what we have in the PECA rules, particularly around cookie consent and particularly around different channels for electronic marketing. So it's worth paying attention to what's happening with that. What I will say is that, as far as I know, the current date of possibly this new e-privacy regulation being published is probably not going to be until next year. And we will have to then contend with understanding how those rules may, if you're UK based, how those rules may apply in the UK in an era where we're likely to be outside the EU. Obviously, we'll know a bit more about that by the end of October, allegedly, if not before. And there are obviously ramifications for GDPR about what might happen with Brexit. But I won't get into that on this particular webinar. But do pay attention to the privacy regulations because they may change all of these rules, and the Brexit aspect may determine how those rules are implemented in UK law, because we won't be obliged to implement them, even though they're an EU rule, but there's a good chance we probably will. So there's some things that you need to think about. But right now we have the GDPR and we have the PECA rules. GDPR, of course, came in last year, and as I say, the PECA rules were first published in 2003. So just quickly reminding ourselves about the GDPR aspects that I was talking about there. We have the security principle, which is one of the data protection principles that says that you are responsible for making sure that you apply appropriate organizational and technological security to all your data processing activities, and there's clearly implications, which we'll cover on the next slide, about where that fits into to your website. And there's also a sort of a general, and I'll sort of cover this in a moment, but there's some general things to consider around security and privacy, and what that they perhaps not directly linked to GDPR, but fit into the security aspect. There's also the storage limitation principle, which is about data retention. So basically the principle says that it's only lawful for you to keep data for as long as you have a lawful business purpose for keeping it. So a lawful basis for processing needs to apply to your retention of the data. But if you don't need the data and there is no lawful basis for processing, and you're storing data within your website, for example, then you need to consider what that principle might mean and what you do in terms of activities around retaining data within the back end of a website. Of course, there's consent and how that fits in. So GDPR consent was I suppose probably the key driver for everyone panicking last year, and in the lead up to the deadline of 25th of May 2018, mainly because it took away the ability to make use of implied consent. So you can no longer have pre-tick boxes, and you have to be very clear about what somebody is going to be consenting to and the outcome of what it is that will happen when they consent. You have to have different consents for different purposes for processing, and you need to be able to demonstrate that you've been given that consent. And I know that some people are being challenged by their customers or subscribers to email lists about, well, prove to me that I gave you consent. So it's not just about the law telling you you've got to be able to demonstrate it, but you've also got possibly challenges from people whose data you're processing. There's also the right to be informed, which is all about privacy notices. So this is the right that an individual has to understand why you've got their data, how you're going to be processing it, what the lawful basis for processing is, how to contact you, and all those kind of things. So we'll talk about that in a second. And then finally, the all-encompassing accountability principle, which is a new principle introduced by the GDPR, which in essence says it's not good enough that you are compliant, you have to be able to prove that you are, and that's demonstrated by the consent requirements to demonstrate that you were given consent, so recording that consent, but it's also about having documentary evidence and things like that. So we'll cover some of these as we go through, looking at how they impact on the websites, but I just wanted to sort of do a quick refresh just to make sure everybody is up to speed with what some of these key parts are with regards to GDPR and websites. So let's move on to looking at website security. Now, as I said, when I was talking about GDPR, there is obviously the security principle, and that explains what you should do with regards to ensuring that all data processing is done securely. But there's some other things that, or other factors which are often considered essential to building websites, which don't necessarily fall within the need for GDPR, depending on what you're doing. And probably the first one right at the top there in that circle is SSL. So this is SSL stands for Secure Socket Layer. It's the bit that gives you the S in HTTPS and shows the padlocks to show that the data flowing between your web browser and the website and vice versa is done through an encrypted connection. Now, this is important if you're collecting and processing data. So sort of traditionally, e-commerce websites don't use them if they don't have the padlock and you haven't got SSL enabled, because you can't guarantee that your billing information and personal data that you're putting into the website is secure. But actually, and Google led on this with their Chrome browser, web browsers now flag up websites that don't have SSL. So if you've got a website that isn't using HTTPS, there's a good chance that your website visitors will get a flag up in their browser in one way or another, particularly if it's collecting data, and that data might even be just a contact form. It will flag up and warn that there may be a security risk if you put data in. So there's obviously some implications there in terms of people's perception. If they're being told by their software program they're using on their computer or their device that the website they're about to use may not be secure, that might put them off visiting your website. So to be honest, if anybody is building websites without HTTPS these days, then they're really missing the point of where privacy fits into this, and that's a key part. And if you're looking to redesign your website or get a website in place, make sure that somebody sets up the SSL or the HTTPS aspect, because that's key now. Obviously, definitely if you're processing data through forms, or you've got an e-commerce site that collects data for purchasing products and services, for example. But even without that, you should have HTTPS enabled, because otherwise the browser will be flagging up a security risk, even if there isn't one. Something else to consider, and this is often overlooked and is particularly challenging to some different platforms for web hosting. So I'll mention WordPress. It's something I know quite a lot about, but one of the key things, and this is a bit like if you look at Microsoft Windows versus Apple products and services, people think, well, Apple has less of a security risk because they're not they're very a niche, and people not everybody has them. But the problem is with Microsoft products is lots of people have them, so they become a target. So people who are running Microsoft on their computers are more of a risk, or sorry, are at more of a risk by being targeted, purely because they're one of a large pot of people who could be exploited by a vulnerability in the software. And this is the same in the website platform world, of which WordPress is beginning to get a reputation for. There may be security flaws in the plugins you're using, even in the WordPress core software, but because it's a very popular platform, it's between 20 and 30% of all websites on the planet are hosted on WordPress. It becomes a target for people looking for vulnerabilities. So there are people who run scripts to find websites that are running out-of-date pieces of software, be it WordPress, be it a plugin, just to make use of vulnerabilities. And those vulnerabilities could enable them to get access to the site and set themselves up with an admin account so that they've got control over it. And of course, if they have control over the website, they can do illegal things like change the content. And I've worked with people who have had their websites hacked and replaced by pornography or selling illegal pharmaceuticals. That has other implications outside the security. You've got reputational damage. You've got the fact that Google will see that you've got a website running illegal content or something has changed in that website, and so it will disappear off the rankings in Google search and so on. And so the key message here is make sure that you keep your website up to date. And if you're not sure whether that's you that's supposed to be doing it, or your web developer or your hosting company, make sure you're clear about that, because you don't want to be in this limbo position of where you think somebody else is doing it and they think that you're doing it and it never gets done. And I've worked with people who have suffered from breaches relating to their website, where they have data within their website which has been accessed by people who have exploited vulnerabilities in plugins and software for their actual website, purely because they'd just taken their eye off the ball and not realized that they had not updated to a latest version of a plugin or an add-on or the website software which fixes that vulnerability. There's some overheads with it because sometimes those updates break other parts of the website, but I would say the inherent benefit of managing your website properly and keeping it updated far outweighs the inconvenience of maybe having to spend some time to fix something when there's an incompatibility. So don't think I've got my website built, I don't need to do anything about it. Make sure somebody somewhere is taking responsibility for keeping that website software up to date. And the other aspect is know who has access to your website. This is a security aspect again, particularly if you're storing data behind the scenes. And the important thing to bear in mind is that you may have plugins, even contact form plugins, sometimes store the data that is submitted in the form in the back end. And so there's a section you can go to and see that Fred Blogs asked you this question on your website with Fred Blogs' name and his email address. Well, that's personal data. So it's not just about because you're running an e-commerce website and you've got a customer database running from the back end of your website or anything like that. It is that, but it also is look at what other data you have within your website and to consider what those security risks are. And one of the security risks is who has access. You might have a developer that did some work temporarily on your site, still with administrator access. Is it still appropriate for them to have access? What happens if they choose to look around the website and see that they've got some useful information? It's about knowing who you're working with, but more importantly, know who has access to your website. Minimize that to the people who really do need access. And you also need to bear in mind the data protection implications of the fact that you would have to demonstrate why these people had access. And if it was somebody who had access that probably didn't need to be, you're in a worse arguing position with the ICO, the Information Commissioner's Office, should something happen about data relating to your website. So know who has access to the back end of your website. Make sure it's only people who are really essential to the running of the website. Or if you've got things built in behind the scenes like customer management platforms and things like that, make sure only the employees who need to have access so that you're minimizing the risk of unlawful access to data and the security risk associated with how they might access that data outside your business. So it's about password security as much as anything else. So from a security point of view, and I could probably go on, probably do a whole webinar just about the security aspects. But the key security things is make sure you secure your internet connection in your website. So that's use SSL, so you get the HTTPS and the padlock for the security. Make sure you keep your website software up to date, and make sure you understand who has access and that they are entitled to that access. And if you've got users, particularly with admin access, that don't need that access all of the time, then consider removing their access and only adding it when you need them to, say, have a look at your site to fix a problem. Now, when it comes to website data, as this rather cluttered slide shows, there's quite a lot to think about. So this is how your website might be collecting and processing data either from the front end or behind the scenes, and we've sort of covered some of that latter aspect just a second ago. The obvious thing that people think about with websites is, have I got the right consent mechanism in place? The important thing to remember from a data protection point of view is when you are collecting data for a specific purpose, it's okay for you to process the data for that purpose. So if somebody fills out an inquiry form to ask you a question, you don't need them to give you consent to then contact you, because they wouldn't be asking you to get back to them if that's not what they wanted to happen. But what you can't do is you then use that data for other things. So if there are other things you want to do with the data, then you need to ask consent. So, so asking somebody to sign up to your newsletter using a form on the website, if that's all you're going to do with that data, then that's fine. You just need them to fill out the form and understand that that's what they're going to be getting. Likewise with a contact form for inquiries. But if you want to do other things with the data, you've got to consider your lawful basis for processing, consider whether legitimate interest is more appropriate, consider whether it's a consent mechanism. But whatever you do, as with any data you're processing within your organization, be clear on what the lawful basis for processing is when you're collecting data via your website. And also, don't forget, if you're running a service that's online that requires consent, if it happens to be of something that a child is likely to be interested in, or is aimed at children, then there are very specific rules in the GDPR that talk about needing parental consent for children under the age of 13. That's a mix of GDPR and what the UK implemented, as in the 13 aspect, is covered by the Data Protection Act 2018. So if you are targeting children, the GDPR says if you require consent for an online service aimed at children or likely to be used by children, you need to get a parental consent as well. So you're going to have to consider how you manage that. I mentioned about the data retention aspect of GDPR and the principles around the expectations of basically not keeping data any longer than you need to. Of course, with unless you're hosting a website where you've got limited storage, there's a good chance that you could easily collect data for years and years. And just as you might consider what you do with your data in the rest of your business, you need to also consider how you retain data within your website, particularly if the back end is storing that data, because there will be a period at which you might have data in there that's no longer needed for proving anything like proving consent or proving that they were a customer over the last 7 years, and that's why you've invoiced them, and proving to the HMRC that this was a valid transaction, etc. So think about data retention and how that fits into whatever data you might be storing in the back end of your website. So back end, just to clarify, because you keep using that term, back end is the bit that's not publicly available via the website. So you have it's sort of if you consider your website to be the front of shop, so people come into a shop and look at your products and services, that's your website. What goes on in terms of the transactions and processing and the storing of orders and the staff that might be running the show, that's your back office. In a website terms, I use the back end to refer to the back end of a website being the stuff that's going on behind the scenes. So if you've got an e-commerce platform, the website will be collecting orders and collecting data about the transaction, the customer, etc. And it will be stored in the back end of the website in terms of how you've got that all set up for managing those orders, processing them, and so on. So think about retention. Think about the right to be informed. Hopefully you've got a privacy notice on your website. Don't fall into the trap that a lot of businesses do, which think that they just need to say on their privacy notice that if you use our website, these are the things that happen with data. You do need to do that, but the expectation is that somebody who is engaging with you, has passed you data, can look at a privacy notice no matter where they are in terms of the relationship with you, look in your privacy notice and see how you process their data. So you might have an all-encompassing privacy notice that says when you visit our website, this is what happens when you say yes to cookies, this is what happens when you fill out a contact form, this is what happens when you subscribe to our email list, this is what happens when you are a customer, this is what happens if you ring us, this is what happens, and so on. So the idea, and if you look at the ICO's privacy notice, you'll see how granular they've gone. The idea is that somebody can say, I am a data subject because I've done this with you and given you this data for this purpose, where in the privacy notice can I find out how that is actually processed, and that's what a privacy notice needs to be. But you do need to consider in your privacy notice what happens in all of the different scenarios where you may be collecting and processing personal data via the website. That needs to be in your privacy notice as well, and that's the right to be informed, covered by Article 13 of the GDPR. And then finally, as I said before, we've got the accountability principle. Understand what you're doing with your website, understand what controls and processes you might need, be that looking at some of the security things and thinking about what your process is for maintaining website software updates and so on, what you do about retention and so on. Think about having a documented process or a guidance document that is available within your organization that sets out how you manage the data protection and privacy and security aspects of your website. And then right on the left-hand side, it says, are you clear what data you are processing and whether you're a controller or processor? Now, it may seem obvious that actually you are a controller because somebody's giving you the data and you're choosing how to process it, rather than somebody giving another controller giving you data to process on their behalf via your website. It's more likely you are a controller. But there are some interesting things happening and that need consideration. So there was a case last week, I think it was, or maybe the week before, of a fashion company called Fashion ID. If you Google Fashion ID and data protection, you should get some more details about it, or have a look at my Digital Compliance Hub website. There's a blog post about it. So Fashion ID had a Facebook-like plugin on their website, which it turns out that Facebook-like plugin collected information about visitors to the website, even if somebody didn't click on the like button, and even if they weren't a Facebook user. And the European Court of Justice basically said that because you're using that plugin, or because this fashion company was using that plugin and determining how that data was going to be used, i.e. passing it to Facebook via the plugin, they're a joint controller because they have control of the data when people arrive at their website, and Facebook has control of what they do with the data when somebody activates the plugin, or in this instance, when somebody views a page where the Facebook like is enabled. So that meant that where they thought that they weren't doing a data controller aspect of the processing, because the data that gets passed to Facebook is up to Facebook, they actually now have responsibility to understand what they need to do. So they have to consider what the lawful basis for processing that data is that gets passed to Facebook. Do they need consent? Do they rely on legitimate interest, and so on? And there's some big challenges around that. So this goes back to also understanding what you're doing on your website, and that's not just about updates, but that's also about understanding, have you got third-party plugins that do clever things that might be passing data to a third party like Facebook, or like a YouTube or a Vimeo account, where you don't have direct control over what happens with that plugin, but actually from a data protection point of view, you may very clearly be a joint controller and therefore have to think about, do you need to ask consent to pass the data to that third party via that plugin before the plugin actually does what it was originally set up to be. And I've got something a bit further on, sort of a sort of secondary note to what we're talking about to consider that's relevant to this as well. So I hope that last bit made sense. It's a bit difficult to try and explain it, but do make sure you're clear what you're doing in terms of processing data on your website. And if there are third parties involved, be very clear as to who's the controller and who's a processor, or indeed in that Facebook and Fashion ID case, who may be joint controllers, and therefore understanding the responsibilities that you have for the bits that you play in the collecting and processing of data. So quite a lot on the GDPR stuff. You've got the security angles to think about, but you've also got to think about where you're collecting and storing and processing data. Is it lawful, and what the lawful basis is, and documenting all of that, as well as making sure you meet some of the other requirements about data retention, right to be informed, etc. So that's 2 slides about GDPR. We obviously need to talk about PECA, and I've just got 1 slide here because that's relatively straightforward. So we talked about marketing consents. The key thing that tells you that if you are doing things with electronic marketing, then you need to make sure the PECA rules apply. And where a PECA rules tells you need consent, then you need to be GDPR compliant consent. But as I said, if you're asking somebody to fill out a form to contact you for the purposes of asking you a question about your product or service, that's the reason why they're giving you the data, and it's lawful for you to process the data for that purpose. What it wouldn't be lawful for you to do unless you collected consent was to then add them to a mailing list. And there's some complexities around B2C and B2B transactions in terms of electronic marketing, which are covered by PECA, but you just need to think about that. But probably the key thing, which are the 2 circles at the bottom of that diagram, is your cookie controls. So the key thing is probably the cookie guidance that came from the Information Commissioner's Office at the beginning of July, which essentially says that if you're running a website that makes use of cookies, you can only place essential cookies, so cookies that are necessary for the functioning of your website. So things like remembering login, remembering what's in the basket of an e-commerce website, that kind of thing. Anything else, you will need consent, or you need to have a legitimate lawful basis for processing that cookie data. Now, this isn't about necessarily that the cookies are storing personal data, because you would think, well, if data protection is involved, then it's about personal data, but it's not. It's because the privacy or the PECA rules say if you place a cookie, unless it's essential, you must have data protection compliant consent to place that cookie, which now means it needs to be GDPR compliant consent. So that means you can't use implied consent. So you can't say, well, if you use my website, you're consenting to the use of cookies. You can't say that what most people are still doing, and used to do, which was we use cookies. You can read about them here in our cookie notice or in our privacy notice. If you don't like it, turn them off in your browser. Just click OK to say that you understand that statement. That is not GDPR compliant consent, and therefore doesn't meet the requirements of what the cookie laws say. So this isn't so much about privacy, isn't so much about data protection, but it's about the link between what the privacy rules say, which is you need GDPR consent, and what GDPR consent actually means, which is covered obviously by GDPR. Now, when you break cookies down, you obviously have essential and non-essential, necessary or non-necessary, whatever you want to, how you want to refer to them. The essential ones you don't need any consent to use, but all the other ones you do. But if you break those other ones down into two separate pots, you will have what are called privacy intrusive cookies. So that's where you're able to use the data that's in the cookie to actually identify somebody and track their behavior around your website or cross websites and things like that. So some of the ad tech stuff, some of the very clever stuff that HubSpot and Acton do with regards to pixels and beacons, which allow you to see that Mark Gracie filled out a form on your website, therefore this person is Mark Gracie whenever he hits the website, and we can see he's looking at this product, so maybe we'll send him a marketing message to say, we know that you keep looking at product A, can we help you buy it, or anything like that. That clever stuff is privacy intrusive, and without any question of doubt, you must have consent before you place those cookies. There are also non-privacy intrusive cookies. So things like Google Analytics, the basic Google Analytics tracking cookies just simply tell you that somebody visited your website and they looked at various different pages, but you can't identify who that individual is. But even though that is not privacy intrusive, the guidance says you need consent. Now, just to confuse things, and I used the word when I did the cookie webinar a couple of weeks ago, I used the word shambles because I think it is a shambles. The ICO specifically set out what different cookies need consent, which is basically anything but essential cookies. But it then kind of says at the end, when it comes to enforcement, there's a good chance we probably won't enforce non-privacy cookie activity. We'll probably focus on the privacy intrusive stuff. So then that leaves you to then make a decision, am I going to run the risk that I don't comply because it's easier to just place a Google Analytics cookie and collect stats about your website, or do you go down the strict route and do what the guidance seems to say is unfortunately being left to you to make that decision. So the bottom line is you need cookie consent for anything but non-essential cookies. Anything but essential cookies you need consent for, and that means you need some mechanism, be it a cookie banner with different options or whatever, to basically place those cookies, but only when somebody's giving you consent. So that was I apologize, I whistled through cookies and consent. When I send around the email with details about the web recording of this webinar and the slides, feel free to reply and say, I want to know a bit more about cookies, and can you send me the link to the recording of the cookie webinar, and you'll get a bit more detail about it. Right, so we've covered GDPR and we've covered the PECA rules, the privacy rules, where they impact on websites. What does it mean in practice? Well, you probably need to carry out a website audit to make sure that you are doing all the right things, and that's going to be I cover things here in that list which I've pretty much covered in the previous few slides. So you need to think about how you keep your website up to date software wise. Make sure that you're using SSL and that might mean making sure you've still got a valid SSL certificate. Otherwise, that flags up as an error to browsers as well. Make sure, and this is a key one, make sure you understand what data is stored in the back end of your website, because you may be surprised to find that when you thought you were just getting an email about your contact form, that is actually a section with all of the data that people have filled in, and you've therefore got a mini database of all the contact you've had for your contact form. You are therefore processing personal data if that information includes names, email addresses, etc. Make sure you understand who's got access to your website and relinquish access to anybody who isn't supposed to have admin access. And if you use a third party to do stuff to your website, just give them access for the minimum amount of time that they need it. But also consider the fact that they will be, if they have access to data in the back end of your website, even as a contractor that might be doing a bit of support work or something that you need changing on your website, they will be deemed a third-party processor because they may coincidentally, accidentally access personal data on the back end, and you need them to be tied to a contract that basically says they won't do anything with that data and they'll just do what you've told them to do. So if you know about the controller processor contract requirements of GDPR, then that's the kind of thing that you need to be thinking about. So this is Article 28 stuff that says don't use a third-party processor unless they're compliant, and put in place in a contract a list of requirements with regards to what that compliance looks like. Make sure you've got the right lawful basis for processing with your contact forms. If you need consent to do other things with data that you're collecting, make sure that those are GDPR compliant. Make sure your privacy policy meets all of the requirements of the right to be informed. Make sure you understand what data is being passed to third parties through the use of third-party plugins, as per that example of Fashion ID and the Facebook like button. And then obviously understand when it comes to that data whether you're a controller, processor, neither, or a joint controller, which was the case in the Fashion ID case. Make sure you've got your cookie consent right, and that includes your banners, not just telling people using cookies, but actually collecting the consent if you decide that you are going to err on the side of what the ICO tell you should be doing, rather than taking the risk that you'll carry on with Google Analytics cookies without asking consent. Put a policy and process in place and make sure somebody owns that, so that they follow that on a regular basis, just to make sure you're compliant, and maybe factor it into an annual review of your compliance. And document as much as you possibly can to make sure that you are able to demonstrate that you've taken note of worrying about GDPR and privacy and where it fits into your website, as you do with other aspects, or you should be doing with other aspects of your GDPR compliance across your organization. So I've sort of summarized those as 10 things to comply or to consider as a website compliance audit. That's probably a good way of you getting to grips with making sure that your website is compliant. Carry out a website compliance audit and review it on a regular basis, which probably means at least once a year. But if you are using external parties to do stuff, then you need to be on that and making sure that you're compliant on whenever that happens. Now, I've added an extra slide, which is a side note, and I think this is a kind of warning to people, if there's anybody on the webinar or watching the webinar afterwards who provides functionality that people might add to their website. So website plugins, if you're a WordPress plugin developer, for example, or you're adding functionality yourself using third-party plugins. So it doesn't matter whether you're a website designer, an app designer, or you're the person who is providing, you're using those services yourself. So the end customer or somebody who's selling a product to use on your website. There's a couple of things that are quite buried in the guidance the ICO provide, and also in the GDPR, that puts a responsibility, because of the data protection principle about data protection by design and default, around making sure you've, as they call it, baked in privacy. So if you're developing a web app that people embed into their website, a WordPress plugin or whatever, then you have a duty to your users, your customers that use that, to make sure that you've considered all the data protection ramifications. Now, this crops up, recital 78 is a key part of GDPR, which basically says you've got a responsibility to make sure you've got privacy whenever you do anything that might include providing products and services that process personal data. But also it cropped up in the ICO cookie guidance, talking about how you implement cookie control. And the ICO basically say, if you're designing and developing websites or similar technologies and they use cookies, you've got a responsibility to make sure that your customers are going to be compliant. Now, the enforcement of that is unlikely to come back on you, because ultimately it's your client that's got the responsibility. But I think this highlights two things. If you're developing websites and software that websites might use, your customers are probably going to want you to prove that you've considered the privacy implications of what they're doing, if that's relevant. And if you are a customer of such products and services, you really ought to be thinking about what are these plugins, what are these bits of software I'm running on my website are actually doing, because there's a liability there if they're collecting data and I didn't know about it. So I think there's a lesson to be learned there. And as I said, nobody really talks about this, and the ICO don't sort of roll out messaging around it or anything like that. So unless you've paid attention to GDPR Recital 78 or even spotted it in the ICO guidance, because it's pretty buried in there as well, you probably wouldn't have thought about that. And that goes back to that Fashion ID and Facebook-like case, where whilst that case was about identifying Fashion ID as the website being a joint controller with Facebook over the data that the widget was collecting, it's actually highlighting this aspect, that if you're building a Facebook-like icon, widget, or using some kind of technology that one of your customers might be placing on their websites, then you've got a responsibility to make sure you've baked in privacy by design and default. So that's a bit of a rush through everything, but there's quite a lot to cover. Obviously, if you need help, then that's what I'm here for. The Digital Compliance Hub provides support to businesses, keeping them on the right side of the Information Commissioner through 3 different ways. We have a helpline which gives advice and support, and it's unlimited email and phone backed up with a library of resources. We can offer outsourced data protection compliance, and we can do ad hoc pay-as-you-go consultancy. So, for example, if you're looking at that list of things and saying, I could probably do with somebody having a look at my website and confirming that it really is compliant and meets all of these things, and it would be useful to have an external person producing a report to confirm what I need to fix and what I've got right, then that's the kind of thing that we can help you with as well. So we've got 15 minutes to go. Now's the time to ask your questions if you've not been typing away as we've gone through. As I say, I hope you found the webinar useful, and I've recorded it, and you'll get a copy of a slide or a link to a page where you can download the slide pack and review the recording. But if you get any questions, then feel free to just ping me a message, and if it's a quick answer, then I'll obviously oblige where I can. Otherwise, we can go through some questions now and just see if we've got any. Okay, so there's a few. Actually, there's quite a few. Right. So if you bear with me while I just work my way through them. Right, so somebody says, so specific consent is not needed if someone is just filling out a contact form. Well, the consent is the fact that they're filling out the contact form for a very specific reason, which is they want to contact you to ask a question. It's okay for you to process the data for that purpose. You will only need consent, or a specific consent, if you want to do something else with that data. So if somebody says, can you send me a price list? That is all that you can do with their email name and email address. That doesn't give you permission, unless other bits of law allow you to then add them to your email marketing list that they get once a week, a brochure or a rundown or something on whatever you send out for your newsletter. So if you are very clear about what it is that somebody is filling out a form for and what they're providing that personal data for, then no, you don't need consent, because it's obvious that that's the reason why they're contacting you. It's a bit like somebody giving you a business card. You don't need to say, I've got your business card, thank you very much for giving it to me. Can I ask you to sign this piece of paper to give me consent to actually contact you? Presumably you gave me the business card because you'd like to keep in touch, whether that's a connection on LinkedIn or a follow-up email saying, hi, it was good to meet you. You need to think about it in that kind of way. So no, you don't always need consent, as long as you're clear as to what it is that somebody's giving you the personal data for. It's when you want to do something outside of whatever your lawful basis for processing is, that's when you might need to consider whether consent's the lawful basis. Do all privacy notices need to have children consent? So the children bits that I was talking about was the requirement in GDPR terms that sets out that you need to get parental consent if you're offering what's called an information society service, which is basically an online service aimed at children. If your service is aimed at children or is likely to be attractive to children and you need consent, then you need to get parental consent if the child's under 13. That's set out in the Data Protection Act 2018 as the age of a child for the purposes of consent. You also need to consider that your privacy notice needs to be written in a child-friendly manner. So the expectation with any privacy notice is it's readable and understandable by its audience. So, for example, I do a lot of work in the education sector. We write privacy notices for the pupils in a way that they understand in their language and in a simplistic way. So we don't talk about Article 28, meaning that we have to do this. We talk about, actually Article 28 is a bad example. So we don't talk about, we will ask you for consent if we need to do something with your data. We say it in a set of words that they're more likely to understand. So when it comes to services aimed at children or likely to be used by children, you've got two things to consider. If you're using consent and it's an online service, you need parental consent for anybody under 13. And you need to write the privacy notice in a way that the audience will understand. So I hope that answers that question. So if we use Google Analytics cookies for basic tracking, we need specific consent. So yes, if you're using the basic Google Analytics package, which most people do, which is it just tracks and tells you a set of stats so that you can see somebody's looked at your website and what they did while they were on it, but you can't identify the individual, so you don't have access to IP addresses or any other data, then that would be a standard Google Analytics cookie. But yes, the guidance from the ICO says even that will require consent, and GDPR consent is the key. And that's irrespective of the fact that there's no personal data being transferred. That's because PECA says you must have consent for the placement of cookies unless they're essential. In fact, there's even a Google Analytics section that says that. Yeah, okay, so this sort of carries on to the next question, actually. Somebody says, well, Google Analytics cookies could be interpreted as essential for operation of a website. Is there a clear info on what is essential and what is not to avoid ambiguity, or is this a grey area? Well, actually, I would say look at the cookie guidance that the Information Commissioner published in July. Probably the easiest way of finding it, because I didn't find an easy way of finding it when I looked for it specifically the other day, other than a direct link I had, is if you go to the Information Commissioner's website, look at the electronic marketing section, which is usually down on the right-hand side, then go to the cookie bit, and then scroll down some of the information that says there's some more guidance in our cookie guidance. Click on that link, and then that gives you the detailed guidance. And it is pretty specific. So it talks about Google Analytics. It's got a bit of an FAQ in there that says, is Google Analytics essential or not? Do I need consent? And they say, well, it isn't essential for your operation of your website for you to have statistics. It's a nice to have, but it's not essential to the running of the website, and therefore you need consent. And it also talks about other things as well. Things like whether the option for increasing the text size on a page to help people who are visually impaired, that will use a cookie to remember that they prefer it at +5 magnification or something, and it gives you some guidance around what that may mean. So I would say, yes, there is some very specific and pretty clear guidance for certain types of cookies in the existing guidance. Where it gets a bit woolly is your interpretation of how they may wish to enforce it, and whether you want to take the risk that they probably will never enforce it against you, or maybe they will. And that's the grey area, I would say. Okay, so right, moving on to what is currently the last question in the list. As I say, use the question panel if you've got some questions. We've still got 10 minutes till I'm going to close the webinar, but obviously I'll close it sooner if there's no other questions. Right, okay, if someone fills out a contact form, can we then write to them to ask for consent if not provided at the time of providing their names, even when we also have a clear data privacy notice saying we may use their data for such purposes? Right, so this is going to really depend on what you're doing with their data and what their expectations are. If you work from the baseline of nobody should be surprised to learn that you're processing their data in a particular way, then you're heading in the right direction. But whenever you process data, the GDPR and data protection law for some time has always said you must have a lawful basis for processing. And so it doesn't matter whether it's data you're collecting through your website, contact forms, whether it's customer data, whether it's marketing data, whether it's employee data, and so on, you always must identify, in fact, you have to document that as well, what your lawful basis for processing is, so that you're clear about what data you have and why it's lawful for you to process it. So in the example of somebody filling out a contact form and then you writing to ask for consent to do other things with it, that may be possible, but it will depend on the context. It will depend on who you've got the data in the first place. It will depend on the type of person you're interacting with. As I say, the privacy rules for electronic marketing are slightly different if you're aiming at businesses and people within business as opposed to consumers. So you've got to get that bit right. But if it's within the context of what, somebody says to you, please send me your price list, and you say, thanks for your request for a price list, here's the price list, that's clearly fine. You don't need to do anything else with that. And it would be potentially relevant, depending, as I say, on the privacy rules, what they allow, but also who it is that you're interacting with, to say, look, we have we change our prices on a regular basis. We would quite like to add you to our mailing list because that's the best way to get access to it. To do that, sign up here to, or reply to this saying you're giving consent. It would be, I would say, potentially lawful for you to do it that way, but it's going to depend on so many different variables, like the original reason you have the data, whether it's relevant to what you're discussing with them, and so on. And the only reason why I'm sort of skirting around a direct answer to that is because the privacy rules relating to electronic marketing to consumers are very strict, in that you will always need consent to be able to send marketing messages to consumers. That means, and also there's plenty of evidence of enforcement by the Information Commissioner, where they've said that asking somebody for consent to do something is itself marketing, and therefore if you don't have consent for marketing, you don't have consent to ask for consent, which would go without saying, of course, because you wouldn't be asking for consent if you had it. So you have to be really careful about who it is you're interacting with and the purposes for which you had the data in the first place. In a B2B scenario, it will potentially be a lot more flexible, but in a B2C point of view, if somebody contacted you for a specific purpose, you process the data for that purpose, and then you wanted to do other things with their data, you would need to ask for consent. But depending on what those things are, it may be construed as marketing asking for consent, and therefore you wouldn't be able to do it. So I hope that answers your question as much as I possibly could, without confusing it even more. Okay, another question. Essentially, how do you get consent for the use of cookies? Well, you have to tell people that you're using cookies, and so the accepted way of doing that is the cookie banner pop-up that you tend to see at the bottom or top, or in some of them, particularly non-EU ones, massive banners that cover over the content that you're trying to read. You will need to implement that banner in a way that basically says, we are using necessary cookies for the functioning of the website, which enable you to stay logged in if you've got an account with us, that kind of thing. But we would also like to use analytics cookies, and the benefit for that is these reasons. So that was why we would really like you to consent to the use of cookies. You can consent by clicking this button to say I consent, or toggling on and off, that kind of thing. So your cookie banner, if you're using cookies, you must have a cookie banner that must provide as much information as possible, and you can link through to your privacy notice or a separate cookie notice about what cookies you're using and the details, because you've got to provide all of that. But your cookie banner is going to be the method by which you get the consent for the things where you need consent for cookies. So strictly you should be saying, look, if you visit our website, we like to use Google Analytics. By default, those cookies are off, but you can go to this section and change your settings so that you can turn it on for us, that kind of thing. So you've got to try and explain that. Probably the easiest example to look at is look at the ICO's website. Their cookie banner, which is actually one that I use as well, is produced by a company called Civic UK. It's really easy to set it up, and in most cases, depending on whether you're doing complicated things, it will be free. And there's things like WordPress plugins. I think I've got plugins for quite a lot of different platforms that you can then implement a similar thing. So have a look at the ICO website and you'll see exactly what kind of mechanism you need to give that, get that consent that you need. And this is why I think it's a shambles, because the ICO say you need consent for Google Analytics. It's very clearly says that. As I said before, there's a section that tells you, do I need consent for analytics cookies? And the answer is yes. And then they say, but if it's not privacy intrusive, there's a good chance we won't enforce it. So do you go through the route of being compliant and sticking to the law by the letter and work out how you implement that consent, and live with the fact that probably most people won't toggle the switch to turn consent on for analytics cookies? So all of a sudden you don't know how many people are hitting your website, what they're looking at, all that kind of thing. Or do you run the risk that you might not ever get caught? And you've got to balance that risk about a number of things. You know, if the ICO investigate you for whatever reason, then that may be one of the things that they end up bringing up as sort of a, and as well, you didn't have cookie consent enabled, and as well, and so on. And equally, it's worth bearing in mind that when I looked at their stats before, they get about 300 to 400 complaints a month about cookies. I think I'm remembering that correctly. So you've got to balance that with whether you want to take the risk of not doing it and or getting it right, in which case you've got to look at the functionality that enables you to do that. Okay, so that's quite good timing, because that was the last question in the questions panel for me to go through. So I hope those who asked questions got the answers they were hoping to get. Well, they might not like the answers, but hopefully I answered their questions for them. As it's now almost 1 o'clock, I'd like to thank you for joining this webinar. As I said, I recorded it, so I'll send round a link to the recording and a copy of the slides so that you can download and use those. If you're worried about what it means for your website, whether it's cookies or general compliance, then get in touch and let's talk about how I can perhaps help you in carrying out a website audit. So thank you very much. Enjoy the rest of your Friday. And enjoy your weekend.